May I have your
Yes,
lordship's
give all the
leave to,
memos.
may I have your lordship's leave to
Yes, give all
mention,
the
my lord?
memos. Consider, give.
There were these for 4 times.
Yes, why it is 4 times and why it is not coming?
And then Tarun mentioned a matter on the list.
Yes,
Item 33 dot 6 recollect that the incident matter retroactive when the ASG government of India was come. His matter was fixed to 37. He did reach. So it is there today in item 35.
The report me is calling on 13th before your worship physically. Maybe taken up on 13th.
let it first remind us, we'll consider it. If it is called, we'll consider it. Don't move.
May I have your lordship's leave to mention, my lord?
Today, what's I have seen.
I'm online, P. Chidambaram. May I lordship's leave to mention?
Yes,
My lord, my order, interim order was passed by this honorable court till next date. And the next date is today. And in the meanwhile, the respondent has said, your interim order is expired. Therefore, I'm not giving you the trading license. Therefore, my IA is filed. It's listed before your lordship at item 56. I'm only requesting sometime during the day, afternoon, before your lordships rise, may take up the IA.
let us see, Mr. Chidambaram, definitely we'll try to reach. Don't worry.
Thank you, my lord.
If it is
Thank you.
not reached, we'll definitely take care of that.
Thank you, my lord. Thank you.
And it's similar there in 35.
Yes. Wait. Let it be called. I said, just remind me when it is called.
Remind you.
Yes, please.
Item 55. Regarding designation of severe offense. Counter has not been filed. Only let it come next to any day.
Sir, let us see. Let it be called. Let us see. Let us see. Just remind us. When you have filed it, then it will appear. Don't worry about it. Yes. Yes, call the list.
Well, for judgment item number 1, WPC 11546 of 2025. Item number 2,
Mr. Bindusar last we is not here. This is matter where we sort of apart from but on Friday they took time on the ground of Mr. Tripathi.
Oh.
That matter, my lord.
So it's.
My lord had formulated a question.
Sometimes you appear, sometimes Mr. Das appears. When the Mr. Das is not there, then you appear. When you are not there, Mr. Das appears. What is this?
Mr. Das only gets requested one parcel only.
Sir, you argued on Friday. Sorry, the last,
Friday,
when this went, on Friday you were not available. Mr. Das took time on your ground that since he is there in the matter, he is not available today, please adjourn him. Please say Monday. Now you are available, but you are asking for a time on the ground of Mr. Das. We are in fix whether Mr. Das will argue or Mr.
Das will admit because we have taken all this.
I do not know.
He has requested one parcel only. He's on his legs. One parcel.
Do you file Vakalatnama, I think the memo of authorization at the time of representing the respondent authorities? You are supposed to file a memo of authorization. Not a Vakalatnama in that sense because it does not bear court fees exempted. Do you file your memo of authorization? Engagement that is required by an LR.
The practice is the councils of for
Is engaged to appear on behalf of the state in this matter.
Lord, it's only when a petition is filed on behalf of the state that a memo is filed.
No, it is always in the respondent also.
Yes,
And,
normally it is.
this formal engagement is done by the LR.
That's right. That is.
Now, Mr. Panda, you had the experience
Yes,
that side
That's
for
why
a
I
long,
said
long,
that when we
long
filed
spell
on
of
behalf
time
of the state.
as additional
we
government
filed a
advocate.
memo.
No, what the distribution system I was just that on Friday or Saturday evening or Saturday when the briefs are interested,
Yeah.
1 to 10 goes without seeing that who is appearing in 8 or 9
Yes,
on the
because
earlier
it goes
occasion.
specifically
Entire
to the
thing
senior.
goes to a particular additional government advocate, and 11 to 20 another. So this way, I think your distribution
Yes.
system
In
goes on.
order of seniority.
But
then.
in all the such cases, there should be a memo of authorization at least.
Now, what my lord assumes is that if a particular brief is entrusted, as
It's-
today Mr. Tripathi appears,
Yes, he should continue to appear.
till it ends, so that he is well acquainted
Conversant
with
with the
what
matter.
transpired in
This
the
is
course
what,
of
Viti, this
hearing.
is what how at least I am groomed in.
I agree.
And this is something very unique I am finding here. May I use the term? It's like a musical chair.
It is because, my lords, of the fact that in every new list, my lords, as per the computer serialization, the matters are listed.
But
And
what is the
therefore,
authority to appear? Simply he has been put into a panel of the additional government advocate does not mean that he is authorized in every case to appear. There must be a specific authorization given to appear in a particular matter.
I think in criminal appeals they are done.
criminal appeal, one has to be designated as an additional public.
Appointed as
Designation is
designated.
usually conferred by
I
the
remember.
What
government.
is this going on now? This is the situation. It's like a passing a buck. When you are not here on your ground, the adjournment is sought. When you are here on others, advocates who ask for an adjournment, on his ground, the adjournment is sought.
Actually, on the last Friday, I was not available. But on that day, Mr. Das already has taken.
Sir, I have not. Sir, on the first day you appeared.
Yes.
Matter was fixed on Friday. Friday, Mr. Das appeared and asked for an adjournment on your ground that he is there in the matter and he is not available today. So we accepted that contention. Yes, he is not there. He has some personal difficulty, has not come. We fix the matter today in anticipation that you will be available on Monday. You are available on Monday today. Now you are saying Mr. Das will argue. So he could have argued on Friday. But he asked for an adjournment on your ground that you are the person who is interested appearing. Now, this kind of a situation, what to do? What the court will do?
Only one person.
Since February, I have been seeing since February, each month and each occasion, you have till 5th of August.
No time you have.
Your appearance is noted.
Yes.
And you are supposed to be acquainted with the nature of the challenge made and the arguments advanced by Sri Gautam.
That's right. One.
Will you wait, sir?
Yes, I'm letting. A point has been formulated.
I have seen the order of 5th
Right.
August. I have seen that order. Why? That is because after reading that order. All possible. What take to that?
Item number 5.
Petitioner with the plus concern of Milan. And for the financial year 2017 and 18.
Why you are not paying? Where is the certificate of completion? Where is the certificate of completion?
Activate completion below. Page 15 annex 2.
Yes, show us page 15.
1.5 million. That is form G and completion.
Where do I get it, sir?
My lord, serial number 17.
Serial number
17. 17.
17. Yes, complete.
Complete. Now, below.
Then why they are not going? Doing
Transferring the wrong account. Of page 26 of the page 26. Annex 7. Annex 7.
Yes, what they have done?
They mentioned that they have wrongly to name of Lakshmi Swami and he has requested to refund that amount. But since 2020,
Which
last three
last
lines,
paragraph?
last 3 lines below. Page 26 last.
Lakshmi Swine has no connection with you.
No.
Sir, if you have committed a mistake, then why he will be responsible for such mistake?
I have taken instruction in this matter. The executive, I talked to the superintending engineer. It will be sorted out within 7 days. So this is why it's concerned. My learned friend is saying it's not connected. But my instruction is that Lakshmi Swine was a subcontractor under him. No. That is she's the subcontractor. But I am the C-class contractor. I have
Sir, if there was a mistake when he was your agent,
Yes.
will you not take a responsibility of this amount to be reverted
My
back?
Lakshmi Swine not bought with me, Miller. Now there is GST demand against me, Miller.
You could not gather it. They say that since you were the contractor,
Yes.
the contractual obligation is between you and the authorities.
Yes.
They have got nothing to do with the Lakshmi Swine. But you have engaged Lakshmi Swine as a subcontractor, means your agent, and then to do the work. They say that yes, this amount was found due, and wrongly it has been transmitted to his account. Now I do not know from where they got this number or the account details, because they are not supposed to know the account details of your subcontractor, because the privity of contract is between you and him. The payment has to be released in your favor, and then you will give to your subcontractor. So that is the money has gone. Why you are not cooperating? You know the subcontractor.
Lakshmi ceased to 2020 to till today. I am cooperating with the opposite party number 3.
Where is Lakshmi Swine?
Lakshmi Swine is not with me now.
So you know his whereabouts, you know everything.
Now he is available in our locality, Miller. He is available.
Available.
Yes.
So why don't you contact and say that what are you doing?
And she is not, she is refused to refund that amount to me.
Not to you, but to them.
That is the manner of transferring the amount to the government account. Now I am suffering, my lord.
Well, you have to take steps. When by mistake it has gone, you should have taken steps for recovery. Why you have not taken steps?
My lord, there are some negotiations between all these parties. You are,
Sir, you are not concerned. The privity of contract lies with him. So
You have admitted that, wrongly credited, then why are you not taking steps?
against Lakshmi, that's your mistake.
You should have asked the bank
and
to,
for only 7 days time.
It's 7 days time. We are disposing of the matter, directing you to pay. 7 days.
you look at this last,
A contractor who successfully completed the work
Subsequently, I found that those are necessary for adjudication of the matter. To illustrate that the parties involved, their right is getting affected. A tender matter.
Yes. What do you say?
No, we have not been served with a copy of the IFR amendment.
You are not so. An interlocutory application is filed seeking amendment of the writ petition. Later to be ultra virus to the Constitution. Very interesting. This is the first time I have come across with this. I can understand the statutory provision to be declared as ultra virus. The letter should be declared as ultra virus. I have not come across. Can you show me any? It's a new concept. I embrace because I am very, I would say, the vibrant, always stand new evolution that is now coming up. Can you show me that where it can be done?
MOD maintains a separate public account.
That is a different. I'm just talking about a provision. A letter can be said to be illegal, not in consonance with the provisions, is against the public policy, what they have said. I can understand, but
Your prayer A.
Judgment
Your
of Delhi
prayer
High
A.
Court in-
please look at prayer A.
A.
Yes, sir.
Please read it.
Issue an appropriate rate order or directions declaring para 9 of the DSW MOD letter number so and so 12/11/2008 as unconstitutional, thereby passing the said portion of the letter dated 12/11.
Now tell me ultra virus theory.
Lordships, a full bench judgment of Honorable Delhi High Court in Squadron Leader Nilam Chahar versus Union of India held that I have appended in para 1 of the petition also.
Yes.
That
What is held?
I have quoted it. I'm reading it, Your Lordship.
What
In our considered view, challenge to the Air Headquarters Human Resource Policy number 3 of 2013. Policy. Lordship,
Remember, policy, scheme, subordinate. I can understand.
Rules.
Rules, regulations.
communications. Hence, the Armed Forces Tribunal is competent to entertain the present petition and the batch of petitions which have laid challenge to various circulars statutory rules, regulations, policies, and other similar communications issued by the respondent government and its organ from time to time.
So what does it mean? Policy, circulars which are statutory in nature. If the authority is bestowed with the power to issue circular in an excise matter, in a customs matter, the circulars are issued by the competent authority under the statute.
And since your lordship, and this
I'm please, you are coining a particular word of a letter to be declared as the ultra virus. That is why I am reacting to it.
lordship may kindly peruse the judgment of Squadron Leader Neelam Chahar.
You want Annexure 6 to be declared ultra virus?
Annexure 6, that is a communication implementing the 6th CPC recommendation. Lordship. Para 12 of the judgment.
Para 1 of the judgment.
Para
First
12.
is para 1. What is the prayer?
This is regarding to policy.
We'll have to understand. And then, in that perspective, this is again, it talks about the another writ petition in paragraph 4. And just below that particular same paragraph, but below that, another writ petition, where it says that the letter communicating the policy, that this is the policy adopted, they wanted to challenge that policy, not the letter.
Yes, your lordship, this particular judgment was regarding to a policy. But in Para 12, the Honorable Court clarifies that even similar communications which are statutory orders, statutory nature, issued by a
Anyhow, I do not know other side who is appearing.
Your lordships may kindly peruse Annexure 6.
We are appearing for this.
85. The very nature itself says implementation of the 6th.
That I have seen. That is, there is already a policy, and by this letter they wanted to implement it.
This is an implementation of 6 CPC resolutions. Sir.
Oh, I understand, sir. Yes.
And by this,
Yes.
implementation letter, the MOD tried to amend the pension regulations for the army, which I challenge. In Para 9, they have tried to amend the pension regulations for army, the regulation 158, wherein creating a different table for commutations. This petition is regarding a excessive recovery of commutations and action. And in derogation to the Honorable Supreme Court judgment in Common Cause versus Union of India, that I have annexed at Annexure 1.
One rank, one pension.
1987 1 ECC. Annexure 1. Common Cause versus Union of India, Para 9.
Which for the other side?
Yes, I'm for the other side, my lord.
Yes.
In this paragraph 1, that is annexure 6,
Yes.
page 86.
Yes. Yes.
It starts from 85.
Yes, yes, I am at
85.
85. Yes.
Yes. That is the circular issued by the Government of India, Ministry of Defence. And that is the subject matter is implementation decision on the recognition in 2008. In the meanwhile, 5th wave commission, 6th wave commission, 7th wave commission is coming to force. So in between, I don't have an instruction in respect to the issue raised by the petition as regard the pension part is concerned by. So I already sought for instruction, but as yet I have not received. But the that is
Do one thing, file a counter, disclose
Yes.
everything, 4 weeks.
4 weeks time, yes.
Rejoinder if any 1 week. Matter to appear after 5 weeks.
Yes, ma'am.
Or all the point relating to maintainability of the writ petition are kept open.
Yes.
Next.
Item 9.
9 also almost all same.
10.
9 they have, yes. 9 also.
On last
Mr. Gevra
occasion,
also filed the same.
That's on last occasion, the notice is issued in item 9, but it is not reflected in.
Notice was issued. I seek certain instruction. I bring to issue record file a detailed counter by.
Same 4 week, 1 week, come.
Item number 10.
Please, Your Lordship. One last item, I've been served with a copy of the counter affidavit. By the state government, take instruction, 2 days time difference. I've served with a copy of counter affidavit on Friday. I sought for certain instruction, 2 days time may be ready.
Yes, on the prayer 1 week, take instruction. Next.
Item 11.
Copy of the counter affidavit is served upon the learned advocate in course of the hearing.
May I pray, can it be taken up one next week or day after tomorrow?
Who is appearing? Looking for a week's time.
He has got the instructions. He has got the instructions.
The difficult person is single bidder is operating.
Yes, yes.
Today they are
Let
provided.
let him file up.
Yes. How much time?
Next week, next Monday.
Next Monday.
Next month.
Item 12.
Public liquidation LRT. The petition is the inhabitants of the Kanpur Moja, the Prasad Nagari near Patak LRT. Here the grievance of the petition is for restoration of water channels which has been encroached and filled up by the OP8 LRT.
Filled up or coverage?
Encroaching that the road has been constructed, and now the CMC OP3 is constructing the CC road over that road LRT.
Concrete road.
That is the issue LRT.
What is constructing a CC road?
CC road
Concrete road.
is cement concrete road LRT over that water channel LRT.
No, that if they can put a slab and it is
No,
an
no
underground
slab.
drainage, if it is an
Totally
underground
filled up.
canal, where is the
Road is
difficulty?
also constructed. over
Always
that.
there.
No,
It should not be open. Is canal used for irrigation purposes or for a drainage purposes?
Drainage.
Both LRT. For drainage purpose in the rainy seasons and the irrigation purposes in the summer season.
How can it be, if the foul waters are being drained there, how can it be used for irrigation purposes?
Yes, Lordship, in the summer season, Lordship, when the canal water is coming, Lordship.
Mr.
like
Baral,
that.
you cannot take what my lord has indicated. You should listen
Yes.
what from his lordship's.
Sir, when I use the word drainage, it has a different connotation. When I use the word canal, then it has a different purposes and the connotations.
Yes, sir.
You should know the distinction.
Yes.
When the canal is always that to bifurcate the water from the main river and then divert it for the purpose of irrigation. So there may be an area where there is no immediate resource of water in the vicinity. So that is why the canal is constructed for irrigation purpose. It says that whether the canal is also used for drainage means all the foul water or a waste which is coming out is really thrown in that. And if it is thrown, then it contaminates the good water. If it contaminates the good water, can it be used for agriculture purpose? I'm asking. You are saying it is used for both. Sometimes for drainage, sometimes for irrigation. How can it be?
Yes.
These are mutually destructive because the wastewater, they have no season. Can there be a season for a wastewater?
No.
Cannot be. Every day, every minute, every seconds it is there.
Madam.
Then
I'm explaining a lot. The area Lordship that is consistent village area Lordship. It was not fully town Lordship. The town system in the so far wastewater is concerned Lordship, that is not there.
so say that it is never used for drainage system. I just ask you
Yes.
that it is never used for drainage system.
The drainage system, I mean to say Lordship, the rainwater.
It is
that
not
is-
a drainage, sir. Drainage means that.
I misunderstood.
What disturbs us is you have put canal bracket drain. That disturbs us.
Yes, sir. Wrongly, yeah.
Because we conceive two different things. They cannot coexist. That's why my lord has said
Now,
mutually.
if the canal, the purpose of the canal is still there, and if they have covered it,
It's not existing law. That is totally filled up by the land developer.
now there is no remnants of the canal.
No, my lord.
There is nothing.
Yes, sir. We are also made.
Now, is there any, whether it has been affected or have they channelized from a different route?
No, my lord. Totally, the water channel has been filled up by the land developer.
Have they provided a separate channel?
No, my lord. No.
How much area is affected by this canal?
Most of the area lordship, the developer purchased some land and they sold out to the other purchasers lordship. And the one Jyotsna Bihar, the name has been given in the project area lordship. The entire Jyotsna Bihar covering the portion of lordship, the canal was there that has been filled up by the OP8 lordship.
That canal or drain, whatever you are hinting at, is it coming on the private land?
No, my lord. Canals were
Then you
there.
said developer has purchased
Private land.
How can it be if it is an agricultural land and mainly used for the purpose of agriculture? Then how the developer has purchased land and then making a development? Has the area through which this canal passes is now converted from agriculture to a residential or homestead?
Yes, my lord.
Then what is the purpose of canal? If the entire area has now become an homestead, then what canal is to be used? The purpose is only to provide a source of water for agriculture purpose. If there is no agriculture activities, then what for?
Our is problem, Lordship, in the rainy season, the water logging is there, Lordship, by that water channel.
So it is used as a drainage.
The water channel, Lordship, by that channel, Lordship, the rainwater were flowing, Lordship. But that has been blocked and filled up, Lordship. By
So
the
when developer develops that land, drain out the wastewater or whatever, he must have taken permissions from our other building permissions and.
What is this? We are, Mr. Das, we are still uncertain on his stand. He is unable to convey the correct way.
They understand from the reputation. His main grievance is drainage water is transmitted to that channels or canals. So that is
Like Taldanda Canal,
yes,
like Taldanda Canal,
yes. Drain water that
rainwater as well as
Then
wastewater.
how
Both.
you have sanitation purpose, how you have, because now I understand from his stand, the area which was actually a agricultural area has now converted into a full-fledged, I would say the urban development has come.
yes, yes.
So how every building, every house there should be a drainage system to drain out that particular waste or the foul water. I am not saying that this canal has to be used for that. If there is a separate system which is already in place, what is the difficulty? The main purpose is drainage.
Sewage water and excess
Sewage water.
will be
This
drained
is
down.
nearer to highway.
yes.
This area is nearer to highway.
Cuttack Municipal Corporation, they have floated this tender in the month of April. Then subsequently, the builder has taken the work. So, if your lordship, CMC, they can better.
Issue notice. CMC is party?
Yes,
Yes, Lordship.
OP number. His basic grievance is against OP number
Issue
3 and 8.
1 and 2,
1 week.
you are appeal.
Yes.
1 and 2.
1 week.
No, 1 and 2.
1, 2 and 6.
7 also.
7 hours.
And private party is also there. 8.
That's the developer.
Developer.
Notice upon all of them.
Man.
2 weeks.
Man.
Next.
3, 4, 5, 8 registered post of the.
Yes.
Item 13.
What?
Item 13. Sir.
Lordship. This matter, Lordship, that the appeal was concluded on merits, Lordship. The subsequent by of remand on the ground of jurisdiction, the same has been dismissed on the ground of limitation, Lordship. And more especially, disclosing the cause of action.
Was there any power conferred upon the appellate authority to condone?
Lordship, kindly, Lordship, last time can inform me to bring the 89. No, versus legal.
What? No, you are referring this judgment. I am just asking you, sir. Probably this is in court. Sir, in relation to a court, there is no difficulty that the power is unbundled.
Lordship.
I am talking about the authority, who is an appellate authority.
Lordship, here, Lordship.
Under the rules, whether such power is unlimited.
In fact, Lordship, in this case, Lordship is mistaken, Lordship, because at any point in time it was never stopped on me. Lordship rightly pointed that 46(1), on the date of communication.
Correct.
It is never.
So have you taken that plea that from the date of communication, when it is communicated to you?
It is never in communication. It is never in communication.
Then how you have filed it?
Lordship, on being obtaining certified copy from the
When?
Lordship, that is your Lordship. Today, Lordship, will give you by one applicable.
This was more. I told you was appeal to communication. And then from there, we can get the show.
Para 2, Lordship, for the additional matter for the additional submitter, the proceeding of the company authority or consequential order under Annex 3 series of the writ petition have never been communicated to the petitioner. Rather, after no.
Very vague affidavit, sir. Very vague affidavit.
Next sentence, Lordship.
Yes, I have seen.
I've given the specific dates, Lordship.
No,
Let me given the date, Lordship.
no.
Because, Lordship, I have the document, Lordship, on 19/11/22.
Yes.
They passed the order to issue me certificate copy, Lordship. 19 on the record, Lordship, I have obtained the certificate copy.
Sir, please, probably you have not understood what pass through our mind.
Sorry, Lordship.
When Rule 46 says that the limitation would reckon from the date of the communication of this. Now, one has to understand the meaning of the word communication. The communication can be more, I would say, in a more loosely sense or in a loose sense. Means percolating a knowledge of a particular fact. Means it is brought to your knowledge that this fact. When you say, when you came to know and applied for certified copy, will you not disclose when you came to know? Because that is the date of the communication.
Lordship, in fact, Lordship, kindly see, I have annexed the documents, Lordship, kindly see. Lordship, that is it, Lordship, annex of 3 series. Lordship. Enter the certificate copy and the communications I have annexed. Lordship, it can be taken up, Lordship, page 42. 42, Lordship, that is.
Yes.
This is intimation to the Lordship, the successful bidder, then followed by agreement annexure for Lordship. They have communicated this on 22/22. In Form F, Lordship, under the rules, that is the information to successful bidder, then Lordship can come to annexure 4.
Yes.
They have executed agreement, Lordship, on
Correct.
15 July 2022. Then I, Lordship, I applied the certificate copy, Lordship. Because to know that entire
Where you have stated,
I have taken, Lordship, that
Where?
in this para, Lordship, Lordship.
please.
Lordship. The petition applied the certificate copy of the relevant orders which made ready by the Tahsildar on 19/11.
Sir, probably my incompetence, probably I could not convey what is passing in. You have not understood
No, I
either or you understood the real difficulty but purposely avoiding it.
I understood, but what I
Sir, when you are taking us to these kind of a communication with the successful bidder,
Lordship,
those of 2022,
Lordship.
agreement is of 2022. Now, first, when you come to know of these communication, when either in the month of 2022, you said that in the month of August 2022, in the month of January 2023, how the source has to be disclosed.
Lordship, January 23, Lordship.
Then the source has to be disclosed.
Lordship, they have issued the certificate copy, Lordship. After only issuance of.
Then
I'm sorry, Lordship, for us.
No.
Lordship, can you see? I was the one of the participant, Lordship. I don't know, Lordship, what is going there. They have passed a unilateral that order, Lordship, and After some time, when I
not know the nuances of the pleading. What can I do? We have to arrive at the conclusion.
Agreement which is entered into, it is in the month of July.
Lordship,
Thereafter, you say that you have applied for settlement copy in November.
no, not November, Lordship. November they issued me, Lordship. I immediately have applied, Lordship. I have applied, Lordship.
Where is that?
That's it.
You have not.
What are issued? They issued me what?
When have you applied?
Lordship, I have applied, Lordship, on Lordship
That is not spelled out in your affidavit.
8/3/2022.
Where is that?
That application with them, but I have analyzed the certificate copy itself, Lordship, in my application.
8/3/2022.
8/3/2022. 22, Lordship.
That was prior to agreement.
Lordship, because the process already, Lordship, they only issued me all documents on Lordship November, in the month of November.
So where is that? That,
Lordship, that I think I
that
have-
material is not with us.
Lordship,
That material is not with us.
that material I have annexed, annexed 3 entire documents, Lordship, they have issued under the.
According to, there is no concept of any pleading, any averment to be made in the petition. Once the documents are annexed, it is a court who has to find out the grounds. After reading the annexures, he will do it, all the exercise, he will decipher, he will presume what is there, everything he will presume. There is no question of any pleading to be made.
Lordship, kindly permit me.
Sir, please consider this. On the last occasion, you did not know. It is the bench who invited your attention that the limitation would reckon not from the date of the order, but from the date of the communication. We said that please tell us that when you were communicated. Now you say that I will, this was silent. You say I will file an affidavit. In the affidavit, what we understood was that you should clearly aver or plead or make a statement that this is the reason on such and such date I came to know from this reliable source that has been passed. Immediately I wrote a letter to them to communicate to me. They did not. You'll have to say that I do not know what is the tenet of the order. Of what I heard, applied. They gave me a copy on such and such date. Immediately I applied for a certified copy on the very first, second day. And I obtained the certified. You say, I do not remember when I got the certified copy. Very easy.
No, I am, because they have handed over the document, Lordship, in the month of January. Though only I collected the document, passed the certificate copy on 8/11. That date I have given, Lordship. Except the date where they handed over, only that I have not pointed out. So kindly permit me, they have to come and give a detailed affidavit. I have done the date of that, Lordship. List of dates I have, Lordship. I can explain, Lordship.
Where you have stated 8/11.
Lordship, next page, Lordship.
Please read it, sir.
Sorry, 19/11, Lordship. 19/11, Lordship.
Where?
Lordship, para second.
That is the 1911.
19/11, Lordship.
That you say that the relevant orders which made ready by the Tehsildar on 1911. So it was made ready.
Ready, Lordship. Then, Lordship, they handed over, in fact, Lordship, that date I have not, Lordship, I am not getting. Lordship.
I understand. January.
January, Lordship.
When you filed the revision on the appeal.
Lordship, on 21st Lordship, on 22 late application. On 25th Lordship, February, late application, not the Lordship application.
So
After remand, then I went for application.
These forms also would not be for the
So then forfeit and detailed affidavit, Lordship.
How many?
I have all the data,
What
Lordship.
the court would be lenient for how many times?
But Lordship,
There must be,
I have
there
an
must be
end
some
of
limit.
affidavit
Age
last.
is given. You are a seasoned lawyer.
No, Lord, in fact, Lordship.
You are a veteran in the profession.
No, Lordship.
You know what is required.
Lordship, in this communication, Lordship, last package, Lordship, I prayed for,
This
who liberty to file an affidavit.
This was, you have come out with the affidavit. What
In
more?
fact, Lordship, last package, Lordship, denied not to file. Lordship, refer to judgment and Lordship, not to file an affidavit. But despite that, I have prepared a short affidavit, Lordship. If Lordship continue to go through affidavit, then I can prepare, Lordship, let it come day after tomorrow. I'll give a detailed affidavit with all documents. Lordship, I have all the documents. So can you see, I have prepared for a moment, Lordship, can you see? I have entered, Lordship, list of text, Lordship, can you see? Enter events, Lordship. Lordship, can you see for a moment, Lordship? Because I could even file a detailed affidavit, Lordship, because last occasion you were denied not to file affidavit and you approved. That's why, Lordship, I filed a small affidavit indicating only the debt. Lordship, can you see for a moment, Lordship? The debt. The petitioner never at any point of time at fault, Lordship. Lordship, can you see? The sequence events I only keep for debt.
You insist,
Mr. Dhalai.
we will see to it and then we will state the law, what we understood the law. It's not difficult. We are thinking
There
of,
is certain facts were not before the authority concerned. Mr. Dhalai,
Lordship,
those facts were not before the authorities concerned.
it is already been dealt with by the appellate authority, Lordship. The very same facts, and so far the delay part is concerned, it has been dealt with by the appellate authority first time. For the second time, Lordship, he is raising this new point, Lordship. He has not gone into the merits of the case. Straight has come on the ground of limitation. For the limitation of point and merits, it's passed the order within the appellate authority.
yes. Yes, we have got.
Lordship, can Annexure 1, Lordship, for a moment, Lordship, can you see? Annexure 1. The same appellate authority, Lordship, can you see? Annexure 1, page 27. Lordship, just I'm reading only two paragraphs, Lordship. Lordship, the page order 824 per moment, Lordship. Lordship, can you come to next page, page 28. Lordship, I'm reading the appellant, his appeal petition has prayed for Lordship for cancellation. For cancellation of lease source granted in favor of lease on the grounds that are mentioned in the aforesaid paragraph and allow him to operate the source. Going through the orders of Tahsildar Birmahapatru and documents found in the LCR, the following deficiencies are found. But the same appellate has dealt with, dealing with the limitation, then he has come to this findings, Lordship. Deposit to treasury challan has not been properly scrutinized by Tahsildar before going for declaration of H1 bidder of the source besides the H1 bidder has also cancelled the fact of non-deposit of challan as revealed from such and such. The Tahsildar Birmahapatru could have made necessary arrangement filing the EC in the name of lessee within the stipulated time as outlined in sub-rule 13 and rule 27 of OMS 16, but no such action has been taken by the Tahsildar. As per the letter was also a joint Secretary Government Revenue Department Odisha Bhubaneswar, it is required to submit the GST registration of bidders during the annual auction and sand public stone mining quarries. The said guideline has been incorporated in action notice published by such a notification, but neither the H1 bidder has submitted, neither the same nor the competent authority has verified before declaring H1 bidder. The Tahsildar Birmahapatru has rejected the lease of the application of Kasina Dhanwar due to non-submission of proof of payment of earnest money and e-challan number such and such with this application, whereas this lessee application of the namely Birenji Singh has been accepted, though he was the defaulter in submission of treasury challan and J certificate which were mandate. In consider the limited prayer, the appellant going through the order documents essential guidelines of the rules framed in this regard and deficiencies described in the described appropriate paragraphs. This court come to conclusion that the competent authority has not rightly observed the formalities as per the rules before going to the selection of successful bidder in the auction at the time of H1 bidder. It has also violated the basic principles framed of the action rule. So all are on merits and consider the limitation it has been dealt with lordship. So now lordship it was remanded only to hear the appeal. Lordship not to deal with the limitation lordship. It has been dealt with by the appellate authority and by this honorable court. So for the lordship, the communication is concerned, lordship, let me only allow me one day, lordship. I'll give a detailed appeal to convince lordship because I have all the documents. Lordship, carry the debt check. I have given all the documents with her. From the day one, I'm trying my best to approach the authority to give me supply me documents to know what is the fact of the judge. Even if lordship, they have rejected my bid, they have never communicated to me. Only lordship, the date of knowledge came when lordship I have the certified copy. And lordship, after 9 months, lordship, can imagine lordship. After 9 months, only they issued a certified copy. And they waited till the entire procedure is lordship to be completed. So lordship, kindly allow me one day, I will detail appeal to all documents I have lordship. Because lordship, last impression only I was going through the judgments lordship that relied upon this Calcutta event, and so far the Kajab action is concerned. I'm prepared on that one. Lordship, can one day lordship come day after tomorrow I will give them all sequence documents. On that day lordship can pass.
And what for you argued so much?
No.
20 minutes for convincing us to grant an adjournment.
Lordship, that's my endeavor, lordship, to only
20 minutes.
not.
Yeah. Yes, that's all. Let us dictate the order.
Day after tomorrow, lordship, I'll take my chance, lordship, convince lordship, because I
How
have
many times you want a chance?
one time, lordship. Only mistake.
So why you have exhausted so much of energy to get this adjournment for 1.5 hours?
Only to convince lordship, I have a case, lordship.
We were thinking about it, and then you immediately started. I have got documents. So we patiently gone through the documents, heard it. Now let us decide. For the limitation act, one has to understand section 3 of the limitation act
That
first.
is there, lordship, but here, lordship, that has been dealt with my humble submission. Once it has been dealt with, can lordship, second appeal with
Yes.
authority. By of lordship, only ground of jurisdiction is deciding on merit, not on the ground of limitation, lordship. The limitation was never a ground, was any lordship consideration before him. He only to hear lordship on the ground of merits. Any travel to the limitation which has already been dealt with by the previous authority by this honorable court of orders.
That's all.
Lordship, day after tomorrow, lordship, lordship only give a lordship sequence of events only to convince lordship. Because there is no communication, only that part, lordship. That is never my knowledge, lordship.
Very dangerous, I would say, their strategic
No strategy.
way of argument.
In fact, lordship, I am not
Dangerous.
merit.
When you go wayward, sometimes on adjournment, sometimes on merit.
No, I have never got into merit, lordship.
You have.
I am convincing.
7 times you said, I have got a documents, I have got a material, come to ensure this, that means you are taking the court to the merit. So let us decide.
So, lordship, so for that,
Let us decide
for the sake of adjournment, lordship.
for these documents.
Lordship, because lordship, kindly remember lordship, I was supporting file and I forgot about lordship.
What to do? Yes. You come day after tomorrow?
That's finished.
And we are dictating the order today. You come day after tomorrow, convince us. No difficulty. Convince.
Permit will not see. That's it. Yeah.
We'll sign it on day after tomorrow, but
That's the other chance. They
Senior friends.
yes.
Right, I from the record by from the last available or to working to know. And so, wherever minds of me, they should be available to this case.
No, there are 2 points. The first, the major point is that whether this judgment, this amendment can be given from a retrospective effect.
Yes, then you also said that.
And then the ancillary point arose that can you take a particular plea which has not been taken by the authority? Even if it is found that it is retrospective.
I was trying to make a research on these points. I got 2 judgments in the Honorable Supreme Court. I have asked me staff to make another copy. Just now he and another 2 copies I had for reading. Only para 12, 13 and 14 of that. Reference yes. 2017 SCC, 2017 4 SCC 243.
Can you recapitulate the fact, Mr.
Yes.
Just recapitulate. He is citing a judgment which is a very, very, I would say, the fundamental principles.
The brief list of dates are there at flag 10.
No, what is the first?
Core issue, I'll just
this
involves the signed soil. This involves the signed soil at the quarry lease for signed mining at Katlak. In 2018, it was given to one Sukkanti Sahu for a period of 5 years. Sukkanti Sahu was declared a defaulter in terms of Rule 4, Clause 9 of OMMC Rules 2016. Since she was the defaulter, the was one Ranjan Kumar Patnaik, who was also found to be disqualified by the Honorable Supreme Court in terms of Rule 27 of the OMMC rules because his solvency certificate was not valid. Then comes the present petitioner, who was the 3rd highest bidder. Now, this dispute, Sukkanti Sahu was thrown out. Ranjan Kumar Patnaik was given a relief by this Honorable Court. It was carried by my client to the Honorable Supreme Court. Supreme Court, my lords, by virtue
That
of
is the second highest bidder.
He was the second highest.
So he was favored with the order by this court, then you carried it to the Supreme Court.
And Supreme Court, my lord,
Adjudged him as that he is not solvent.
he's not so, and doing so, had held that the bid of Ranjan Kumar Patnaik was non-honest and void,
So you become automatically the second.
the highest, because the H1 is gone.
Second, meaning
My
you
lord.
placed in a position of a
Of
second
second.
highest bidder.
Right.
Then
So now, after the judgment of the Honorable Supreme Court, which came about on 3rd March 2023, I was the only person left in the fray. H4 was also there, but they didn't give it to me. And then now they are relying on an amendment which came on 24/4/2023.
what that
That amendment says by way of an e-auction. Now, in 2018, e-auction wasn't there. Of course, there was an auction. So now they are relying on this 2023 amendment to say that since e-auction has now been introduced, we will not give it to you. That's the basic case. My submission is, I have got the judgment also, if your lordship wants, that these subordinate rules have to be always prospective. I'm just giving that. 2021 10-210. Two 2021 10 SCC, page 210. And the relevant paragraphs would be 16 and 17. Para 16 would be at page 218 on the left hand side. I've also given a copy to my government.
Yes.
And since this is a delegated legislation, there are several that
Vatica, income tax.
since this is clear, I have picked up this.
Yes.
Para 16, we have clearly discussed. This is a delegated legislation. Is that and the list of dates, if it also picks up the amendment itself, it says that it will come into effect from the date of the Gazette notification. That is also an indication that it has to be from that date. And here it is 24th April, just below the list of dates I have given.
This court in a taxation matter that said in Bansapani mines.
And
Bansapani. It is court number 5, 2015 or so.
That is very prospective.
It will be prospect. And all that, my lord,
So, no. If date of effect is given, so
Then it will from that.
it cannot be retrospective. The spare part was not there in the definition clause 2, clause 8. So that had been introduced in 2008. So it cannot be given retrospective from 2005. So that was the concept.
and just to persuade, it's not that it's directly on the point, is that this principle of restitution, because of course time has gone, but I carried the matter all the way to the Honorable Supreme Court. I succeeded. The Honorable Supreme Court said that his bid was non-honest and void ab initio. Thereafter, I don't get it. Then, my lords, the entire exercise becomes. So, just to persuade, if your lordship wants, I can give one judgment. It was 2003 8 SCC 648, Southeastern Coalfields, where they have 6 to 28. Of course, there are civil principles emanating from 144 CPC, but in para 26, what would be important would be
in our opinion, the principle of restitution takes care of this submission. The word restitution in its etymological sense means restitution on the modification, variation, or reversal. So here, after the reversal of the Honorable Supreme Court judgment, my rights get crystallized. And it's basically to persuade your Lordship.
Now what they have done?
No, they are not
scrapped it. They are not given to anybody.
No, they have not given it to any.
They are now contemplating to do it in e-auction.
In e-auction. And the provision itself says that I will match the highest bid. It's not that I will stick to my bid. Bidder to get. That the provision itself is there.
Yes.
On that judgment only, since it is not a concluded contract, no right has taken, and e-auction. Certainly, it has come in the midst. We proceed the amendment that come in the midst. So our generation of revenue is of paramount importance. That's what Honorable Supreme Court observes. So e-auction certainly permit to be generating more revenue.
That's all. Anybody? Anybody? No, nobody is here.
No, it's between us.
Now it was for a period of 5 years. And extendable or renewable or
yes,
fresh auction has to be undertaken.
There is a specific
Under the
provision
rule?
regarding the period of lease. 5 years, extendable up to maximum 10 years.
10 years.
That would be Rule 8 of the OMC rules. Eight 4. These are quarry releases for sand. 8.4 of the OMMC rules 2016. If the Lordship wants, I can place that. Period 8 begins with periods for which prospecting license from mining lease and quarry lease can be granted for the specified minerals. And subclause 4 says maximum period for which quarry lease may be granted shall not exceed 10 years and shall be subject to such terms and conditions as may be specified by the competent authority. Proviso says minimum 5 years.
Yes.
And if the Lordship wants, the definitions are there in section 2, small AA, which defines specified minor minerals, and the schedule gives what are the specified
We
minor
have already held in one of the
minerals.
This is, I think, the last week we delivered the judgment.
Minerals.
The chapter 3, chapter 2, chapter 3, and chapter 4, we have made a distinction
Minerals.
that specified minor minerals and the quarry leases under the schedule 4, entry 30.
Minerals. Indeed.
We have taken that. What should be the
Ordinary
rate?
is
100 rupees or something.
Minerals. And this provision regarding matching the H1 bid is in 27 sub rule 9
Where is the order which they have given?
That would be Annexure 9, page 84, and PDF page would be page 181. This is by letter dated 5/6/2020. And it simply says that because of e-auction, we can't give it after the new amendment has come. Page 84.
Where is the judgment of the Supreme Court?
That will be Annexure 4. It begins from page number 36. That would be PDF page 133. The date of the judgment
In the last page.
Page 57, 3rd March 2023. And at internal page 54, the finding regarding the solvency certificate being void ab initio is there. Just above para 8.1.
They handed they decided to give a lease to the H2.
Yes.
They gave or they
gave. They gave, he operated. And in paragraph 10, it was specifically
when they
cancelled.
gave in 2021.
The exact date.
24 3.9.
1/1/2020. That is Annexure 1 at page 15.
Where is the order of the collector? 24/3/2021.
I think that is not been. Collector's order has not been.
That is very important. Is there any reflection of that order in the judgment of the Supreme Court?
No, the High Court order we have got. You can pass on the High
Is there
Court.
reflection of that order?
No,
Page 56, paragraph 10.
No, that I have already read.
no.
I'm talking about the content of that particular order. The content of that order, I just really wanted to know.
Some description is there in the order of the Honorable Supreme Court. Paragraph facts have been elaborately discussed, my lords, from page 37 onwards. And so far as the collector's order, my 41, paragraph 2.4 onwards. In 2.5, cancellation is mentioned. And the reason, there is a brief description of the reason at that's page 43, para 2.5.
So that was an order of 21-3 order, which is quashed. What is that order? Which is restored, cancelling, 24-3 order.
24, my lords, and the Honorable High Court restored it.
No, he has not reflected that what 24 simply says cancelling. Thereafter, anything stated by the collector. Simple calculation, cancellation, or that it was followed by some. Don't you have the copy of that order 24-3?
You must be able to read 27.
Earlier writ petition must be there. Right away, we don't have it. Lordship, once we can file it by way of a mail. The order itself.
Give it to us.
No. we are trying to get it, my lords, but from the Supreme Court order, all that I can say, my lords, is that the collector cancelled the lease. That recording is there.
We understood the point which he is taking.
They are saying that it has to go in the impugned order. They are saying that it has to
What
go.
he is saying is that even if you may declare S3, then if you have deposited the earnest money or the other thing, that does not create any vested right in place in you to have the lease in your favor. Granting of a lease and being adjudged as the highest bidder are two different concerns.
These are the two competing.
So if they decided not to give, then in that event, it does not have a vested right in it. This is what I understand. But till date, they have not indicated any document that.
They have not. My lords,
They have not. Simply they say the new rule has come.
my lords,
It should be done by e-portal. One can reasonably infer that they wanted to cancel it, not to proceed on the basis of that.
it's that
That's a reasonable inference one can draw by
that is
virtue of this stat. There are two aspects why we are asking. In the collector, well, there is a very important aspect. H1 defaulted. H2 lease was executed on the basis of a solvency certificate. Collector permitted him to replace the certificate. Then the objection was raised by you. And ultimately, they cancelled that particular,
cancel the lease.
and then lease.
Cancel the
That
lease.
No, it can't be done. Now, whether he stopped to that extent or he went a bit further.
In cancelling
By
the
cancelling, he went a bit further or stopped.
that's the doubt, my lord. Then I have to produce that order of the collector. Because without that, I don't think it's right. So, we have a soft version. We can show it in the
Last portion of the rule.
my lord.
Please read that last paragraph. It's the most important.
Very interesting. I can say, my lords, the impugned order simply says that in view of
Now, should I be more clear?
no, my lords, what I was trying.
Now I am making both of you to what is passing in our mind. The Supreme Court order, if you read page 56, Supreme Court simply says two things. The lease executed in favor of the respondent number 1 is H2 is hereby declared cancelled. It will not be taken into consideration. Simultaneously, the Supreme Court says that the order of the collector is restored.
Order passed by the collector. My lords, we are giving the
High Court's order was set aside. Order of the collector was restored.
Page 56, last of 6 lines.
we have it in the tab. We can also mail it.
So once the order of the collector is restored, the order of the Supreme Court, then the whatever has been directed by the collector becomes applicable with any complements.
So the restoration is of the order of the collector cancelling the lease.
Means the court held that the collector's order was correct while cancelling the lease. If the collector, after cancelling the lease, have said something more, that let the process be issued with entry, then you have something on and this judgment will not come into
No,
play.
that is not there. That
Then
line
in
is
that
not.
event, in that event, can you now?
My lords, I'll
That's
say.
the only question. So he succeeded on the story. Then it's very difficult on your part.
My lords, that's the reason, my lords, we will forward it.
Then, sir, it is very difficult.
There, my lord, that's the reason why Mohinder Singh Gill comes. The impugned order.
We will say that this, they cannot take that particular. But definitely they can take a plea of a scrapping the entire thing.
Now, scrapping hasn't happened.
If they say
It's a matter of inference.
Inference.
My lords,
I said they have this term said, but from the tenet of the order, one can reasonably infer that they do not want to continue, they wanted to go for a fresh.
my lords, that is my humble submission, is that inference in view of Mohinder Singh Gill at this stage, my lords. Now, there is one more document. If your lordship wants
We are remitting that. Let them decide.
my lords, there,
They can't. When you have come here, we are remitting, saying that he can't because of the MS Gill, you can't. Take a decision. Now they will take a decision. I was keeping mum because I do not make them wise. Now they have become wiser.
No, of course. But in terms of Mohinder Singh Gill, your lordship can always remit it back to take a decision.
That is the only option. There is no other option than to remit back. Remit.
There is one document. Of course, it's not very positive. Page 77.
No, we have seen the order of the collector.
No, my lord, the Tahsildar, who was the tender inviting authority, there is one recommendation in 2023 in my favor. Just one document.
Prior to April, 23rd April.
Yeah.
That is 23rd April or after 23rd April?
No, pursuant to the orders of this court to consider my representation.
That is over.
There, I'm just reading that. What the Tahsildar Cuttack writes is that in view of the above facts, the case record of so-and-so and representation passed in terms of so-and-so and Supreme Court may be transferred to Mining Officer Cuttack for issue of Form F, observing the required formalities of ONCC so-and-so and subsequent modification thereof, as well as execution of lease deed in favor of Sri Mahanti as H2 bidder with respective so-and-so.
What is the date?
Date my 10, but the decision was in terms of a direction of this court to take a decision on my representation. Date is 2010-2020.
That may not be relevant because that you carried the matter to the Honorable Supreme Court passed that order. So that may exist.
No, in fact, there would, if your lordship also there
in that order.
in the SLP,
the collector's order is all right.
other developments.
Let the authorities.
We went in a contempt before the Supreme Court.
No, we will simply say, so far as I was given, we will say that they cannot have this one and the rejection cannot be done in this week. And they have to decide it on merit. Let them decide on merit. If they decide, that's fair enough. Let them decide. Yes.
There was a recommendation by the council.
You have to decide.
I was stayed by my landlord.
Item 4.
Lord, may I mention? Lord, may I mention item 19?
May I just make one small submission? Item 4. Item 4. Since the Lordship is taking a call to remit it, my Lord may give some observations because this man has fought all along this.
Note 14.
The item 48 paper shall pass over. I think will come in the next week.
Item 15.
When the tender was quoted,
Yeah.
tender was quoted for implementation of net testing facility in 45 plot centers. I'm one of the bidder.
Unsuccessful bidder.
No. Tender is going on. Now there are some technical specifications. So present petitioner along with other bidders, they have petitioner along with other bidders, they have made recommendation for amendment of the bid specifications. Now you see my grievance is at page 83, point number 9. All equipments, parts, just got it, page 83. Clause point number 9. All equipments, parts of the system supplied to have been approved by US FDA or CIVD along with the DCGI approved version consist of all compatible equipment, hardware and software designed and set up to perform the protocol as per instructions by the manufacturer for net as a protocol. Then, my lord, petitioner made a representation annex 2, page 116. I sought for modification of that technical specifications as because I am the only manufacturer in Asia and there is no manufacturer company. So in view of directive issued by the government of India to make in India successful, there are some direct I also you are seeing. So I made a representation along with other bidders. So they have amended to certain extent. Now you are seeing. And next 8, page 127. Except me, others were European specified companies. Let's see, come to 127, annex of 8.
Which serial number?
4. Lab, my lab discovery. Here, my request was considered along with others. Here, they have added. Let's see, come to 9A, last column. Last.
Product.
Clarification oblique amendment. Table last.
Which page?
127.
Yes.
Yes. 9A. Standard or quoted product. The quoted models of the net testing system should be either USFDA approved or European CE certified as per IVD standards or IVC.
So they have included many.
They have only included BIS standard. BIS standard they have included.
So you have
Now, my lord, I have no. Now that is the problem. Now there is no company in India or Asia having BSI standard. As because there is no specification in India, I am the first manufacturer of that machine. I am ISO certified.
That is done by or not an.
Yes, or.
Or.
Now your ship come to.
You are coming within that.
My lord, your ship come to. Yes. That is European company.
Or
yes.
European CE certified.
Yes.
Whatever. So everything they have make it more wider.
Yes, my yes, so, yes. I do consider my.
So you come under the purview.
Now, my lord, in view of that, I am coming. Your ship come to
annexure 4, page 122. What is the directive of the Government of India?
Yes.
122 page, annexure 4. The undersigned is directed to refer to minutes of 8th standing committee meeting of DPIIT held on so and so to review the implementation of public procurement preference to make in India order 2017. It is observed that in spite of this office OM dated so and so and so and so, procuring entities are still incorporating restrictive and
No, that is what they say, that they should not strictly follow only the US FDA or
Yes,
European
ma'am.
CE
Yes, ma'am.
certificate.
I do.
They should include. So they have expanded it, no problem.
My lord. Yes, ma'am.
They have
Next, my lord.
BIS as well.
Next, my lord. I made representation. What is the difficulties we are facing? Indian government facing.
What?
So, annexure 9, page 142.
Yes.
I made another representation
Yes.
on 24th July 2025.
Yes.
That's it. Point number 9. Last column. Justification of the request.
Yes.
As per the notification issued by Department of Pharmaceuticals, Government of India dated so and so, BIS shall be given with BIS certification for in vitro diagnostic test system, qualitative nucleic acid based in vitro examination procedure for detections and identification of microbial pathogen. However, we have repeatedly contacted BIS for the same, and they have officially responded that currently they do not have procedure and empanelment laboratories for giving this certification. They have no such laboratories. So they turned down. That is, my lord. Next, also I made representation, and your we got license from ISO, ICMR, and my lord. Central government also to manufacture the product. There is annexure 11 series, 146. We got license to manufacture. That has been approved by the central government.
Yes.
Annexure 11 series, my lord.
Yes.
Next, my lord, annexure 12 series is the.
What you have given a license?
Yes, yes.
What for?
That for that particular machine, my lord. Nucleic acid based multiple screening kit for HIV, HBV, and SCF.
Yes.
Next, next page 147. This is also license given to nucleic acid based. We got license to manufacture the machine. There is no dispute, my lord. Now you are see annexure 12 series. We got ISO certification also.
Yes.
To design, development, manufacture, sell, and distribution in vitro diagnostic.
What's the difficulty? You have been included. Where is the difficulty?
It is not available.
So
We have not
they
been.
say in that they say it's an optional one.
No, my lord. Or.
Alternative.
We have three things, my lord. One is US FDA, that is US Food and Drug Administration, given by certificate given.
You have that?
No. I'm Indian company. Now other foreign companies are now they have put their bill. As you know, I'm Indian and I have no such certificate, though I am having all good. And there is no specification prescribed by the.
Sir, this relates to a health sector.
Yes, ma'am.
There can be compromise on.
Yes, ma'am. That's why, madam.
It relates to a
Madam, my limited vision. My limited vision.
Madam, these three are product quality standards which
Yes.
are required. Initially, in the original tender call notice, it was only US FDA.
I understand. Then you have expanded it.
Yes, madam.
So they are saying that in India, BIS certificate is not given to anybody.
But some certification is required.
One thing. Here, certain products. This product is included therein. I will verify.
My let's,
No.
He's denying.
my let's.
Yes.
That I'll show you.
Aerated water, water products, and any other products, they are given BIS.
That I will show your things.
Your standards described for certain.
Your my affidavit.
It's here, that's if I may submit one.
So whether this has to be mechanically done or you set up the
SDA and SC note certification. Considering that tender call note, the committee after thorough inquiry passed this minutes and accordingly.
nature of description made there. It means that this only covered with respect to citation with foreign companies. These indigenous products, manufacturers, they are unable to participate because of this law, because BIS is not given to any of the manufacturers in India, and he is the manufacturer nation. And whether you will check up whether BIS is manufacturing the commodities in the line of commodities which is requisition by him.
Just to come to my affidavit, page 15, at page 12.
Oh, sorry, the clarification is page 142, when you have made further representation. So they have said that we can't compromise on a quality. Even a National Institute of Biologicals, that's a. We have also suggested that we know the sensitivity and the specificity of the testing which is required. And then they say they should be sufficient for providing for the highest available accuracy and precision for the detection of HBV, HCV, and HIV-1 and viral markers of the donor plasma.
Yes.
Therefore, we request to make BIS certain as optional requirement. So they have already suggested for optional.
My lordship, there are three things. Or BIS, or UC, or UC.
What is the meaning of this word?
Not getting. You come to serial number 27 9. Serial number 9, justification.
Yes.
Column.
Yes.
Answer 9. 143.
Yes, I
Page over to 143. Last 3 lines. And the demand for it. Therefore. Got it.
Yes.
Optional.
Option means one of the certificate must be required out of 3. Now there are other two currently combined. Yes, madam. I do consume. I do consume, madam.
Those highly contagious the disease and plasma means
Yes,
that
yes,
they will
madam.
be
Yes.
injected to a
Yes.
needy person. That's
Yes,
the blood
yes.
transfusion.
I do.
So they have to rule out if the standards are high, whether the Indian manufacturers are conforming to those or not. We are not concerned. We are simply concerned with the well-being and the health of the citizen of the country.
Yes.
And if that standards is there, we are not going to interfere and then say so.
Yes, madam. Next, your
Whether you are there or not.
Madam.
Government of India has set a standard.
Yes.
The Government of India has
My
made a.
prayer is that let them follow the standard prescribed by the government of India.
This is what they are saying. They
You
are
have to come to
following.
you have to come to
At page
NH.
143, what they do not have, when they say they repeatedly contacted BIS for the same.
That our
And they have officially responded that currently they do not have a procedure and independent laboratories for doing this clarification. Now, we submit that our essay has been quality tested and verified by the reputed institute, National Institute of Biologicals,
Yes.
Government of India.
Yes.
3 batches analytical sensitivity and specificity testing.
Yes.
This should be sufficient for providing the highest available accuracy
Yes.
and the precision for detection of these disease viral markers
Yes.
in a donor plasma.
Yes.
Therefore, so he has said that the Government of India, this
Man,
this
this is my
department,
representation.
institute
This is my plea.
has said that no,
This is my
we do
plea.
not.
This is my representation.
Whatever.
And yours
Whatever
come to.
they say optional, let them. We will not.
Yours come to.
The health center.
Yes, I do want to know. Yours come to page, Annex 5, page 123. The directive of the government of India.
This is your suggestion.
Yes, that's my suggestion.
You wanted this to.
Yes, yes, that is my
Whatever
suggestion.
they are made to.
Yours
What they have done.
They have made or as alternative.
Well, one
They
thing-
have accepted your representation.
And one thing,
Huh.
here I got
They
license
said-
from central government.
Where have they said, result of your.
Result yours, my affidavit.
This is too adventurous to be.
Yours count my affidavit.
No.
Yes.
They
They turned down my affidavit.
Where is it?
My affidavit, flag B. Yes,
Where?
my affidavit. I filed an affidavit. During penance of this petition, they have rejected my claim. By way of affidavit, I am filing.
No change.
No check.
They have not compromised with the quality.
Your ship have, my suggestion was no change. Then they extended the period of contract and yours will come to Annex 15, page 12. That is very important. What is the reply of the BIS? Page 12. I have applied. Standard not in certification, please contact BIS. There is no standard in the BIS. So this is the first machine in India, in Asia, which is now implementing. I have already set up my machine in different corporate hospital, and I got license. I got an award from National Technology Award 2023. Come to Annex of 17, page 15. That's the order, 2017. Make in India order.
Sir, we fully appreciate it.
Madam. Yes, you come to page 17 of the epidemic. Page 15 of the
But
epidemic.
is it applicable to Jackson?
Yes, yes. That I will show. Just you Annex of 4, 5, and 6. Government of India has directly issued this that all the
This is for this UF, you want that for this litigation, you have to consider. They have considered to be something we are.
just you come to Annex of 6, page 125. Last directive of the Government of India. 125, page Annex of 6. This is issued by the Government of India, Minister of Health and Family Welfare. The Department of Health and Family Welfare had earlier issued an OM number so and so, advising all the procuring entities under the department to comply with the provisions of the public procurement preference to make in India out of 2017. and desist from inclusion of the restrictive and discriminatory clauses, then insisting for USFDA series standard in their procurement of medical devices.
No, they have not, they say, not insist
Yes.
that it should only be this.
Yes.
They have accepted it and they include it. Whether that is there
Now
or
they have,
not,
my lord, now they have
that,
included
that we are
BIS.
not going to.
Now, my lord, they have included BIS. Yes.
We do not. we do
And
not, that is
BIS,
up to them.
there is no such company or machine or equipment.
Whatever we are not.
And your Lordship, what is the order? Your Lordship, the government of India is directed to implement 2017 order. That is annexed to 17 page 15 of my affidavit. There is a penal clause. Lordship, from 10, order 10. Page 21 of the affidavit. Lordship, what is? Affidavit, page 21. E. Specifying foreign certifications on reasonable technical specifications, brands, models in the bid document is restrictive and discriminatory practice for suppliers. If foreign certification is required to be stipulated because of non-availability of Indian standards and or for any other reason, the same shall be done only after written approval of the Secretary of the Department concerned or any other authority having been designated on such power by the Secretary of the Department concerned. And non-compliance is 10A. Action for non-compliance of the provisions of the order.
What you are referring, I am unable to find.
That is my affidavit.
Which one? Lecture 6. The page 21 of the additional affidavit.
Additional affidavit?
I am looking at it.
Yes, ma'am. Annex of 17, 170. Under affidavit. Lordship, come to page 21.
What 21?
Page 21 of my affidavit.
Yes.
10E. Specifications in tenders and other procurement solicitations.
Where I will get it?
Last line.
Specification, foreign certification.
Yes, madam.
He is reading something else, so that's why I am fixed.
This is the same foreign certification.
Yes, madam.
Unreasonable technical specifications.
Yes.
You see that you are reading
And
something else.
models and all these things.
Models in the
Models,
bid document.
brands, models in the bid document is restrictive and discriminatory practice. Again, now I am the only one local supplier. If foreign certification is required to be stipulated because of non-availability of Indian standard, I am ISO certified.
ISO is a different one. They wanted something different. ISO does not mean that these standards are.
And central.
It's not ISO generalized everywhere. The ISO, even if a repeat product is given, these are the company that is the ISO compliant company. There are certain different parameters for ISO.
And Central Drugs Control Alliance also you
participate there.
I have participated.
But that's all. Participate.
I have participated. Now neither I am having BIS nor any European certification.
Let them take a decision thereafter about them.
And in pre-bid.
Still the period for submission has not lapsed.
No. They have extended.
No, that's all. Let them take a decision.
And they have already taken decision. There is no
expedition merely on an apprehension or presumption
for another period of 1 year on two grounds. My lord. One was regarding the government's notification which was issued during the COVID period, because this agreement was in 2020.
So what they have done?
So Lord, they have rejected it. I've written to them. I'll just bring
Let
them.
them file, because you are asking for a quashing of that particular order, so they have a right to file their own petition.
No, my lord, I'm not on that, because the period will be over on 16th of August. So if my learned friend can get, because this is only for the extension, and I'll just, my lord, do.
So let them take a decision and file why they are not extending the.
No, they have already
There is some
rejected.
demand. There is some demand.
No, demand they had raised, I have deposited. And that was in June 2025, where they mentioned for the financial year 25-26. But since the period is not ending on the original period, is ending on 16th of August. So I made a request that it should be subject to your lordship's
Right to extension is within your right, file your affidavit within a week. And rejoinder if any within a week, matter to appear after 2 to 3 years.
Minute 23, the next party order under section, next party order under section 73(1) of Finance Act, it's covered by minute. Similar. Corrected. Yes, sir.
Item number 24.
Item number 24, your lordship on the last occasion has directed to take instructions. Your lordship, the order which has been challenged, there was 73 and subsequently 63. Your lordship, we have rectified the 63 order and we have withdrawn that 63 order. That proceeding has been dropped, so his there has been accepted.
So what? So what? You want to withdraw? Then?
They have withdrawn, so. Like,
No. You want to pursue your petition. Because you have
Withdrawn, so yes, my lords, my prayer is already complied.
So do you like to pursue the petition, or you wanted to?
Withdraw. Please post off as it.
We will say that disposed of as infractions. Yeah. The petition has virtually been.
Item 25.
Disposed of.
So, my
Your lordship, in this case,
25.
your lordship, in this case, your lordship was also directed to take instruction. Here, two assessment orders have been passed, your lordship. First, for a period April to September, one assessment order, and April to March, another assessment order. So the entire grievance of the petition is that the assessment has been completed from April to September, whether it is within that complete periods of assessment or not. Here, the assessing officer has admitted, but he has done a mistake. Again, another mistake, your lordship. I concede myself. Let it be restored to the AO for verification. Your lordship, what happened? He has admitted that it is a double assessment order, and that is well within that. But he has dropped the initial order. Where he has complied everything. So I admit, your lordship, since the assessing officer himself admitted that it is repeated. So the entire period assessment, let it go to the assessing officer for verification, and the it will be deducted and subsequent period. Because the balance period, for the balance period, admittedly turnover is there. He is admitting, my learned friend is admitting of the balance. Because so far as the period.
There was overlapping.
Overlapping.
So overlapping will be
And in
deducted.
fact, your lordship, 2 times scrutiny was done and same officer has passed orders under section 73 for both the times, your lordship. And for the period,
What is that?
I'm admitting and
your lordship, you take on senior submission and dispose it.
instruction, instruction.
Instruction is there. Yes.
But in the instruction, your lordship may kindly look into. Subsequently, the taxpayer issued so and so on the same excess claim. The taxpayer has issued demand form undated so and so for the past period for the same excess claim of it. As the taxpayer has issued double demand order for the same issue, the undersigned has decided to drop your lordship previous part to drop. He has dropped the previous part. He should not drop that. He should have rectified the subsequent assessment order. I understand.
What will you do?
The
You
subsequent.
will do that or you will do that?
Your lordship may direct. Your lordship may direct, remand matter. Remand the matter to the assessing officer. Because prima facie it is
For rectification.
for rectification of the entire period. Without the
Already entire money has been deducted.
Once he has taken that decision, he has dropped already that other.
prima facie
That
that is
has
wrong
to be
decision.
revived.
That is what is wrong.
So
For that period,
That's why
entire
I'm saying.
money has been recovered. And
then how will you sort it out?
So that period has been dropped. Automatically it has been dropped. It has to be dropped because he has complied that
You
order.
should have taken up in so moto.
Your lordship.
So moto. The commissioner should have intervened.
Let it be remanded.
What demand?
Let the order to be remanded.
Why not commissioner? Why should we?
108, your lordship.
Yes.
The input order, your lordship, is at annexure.
8, your lordship.
Annexure 8, which is for the from the period April to March. That may kindly be remanded to the assessing officer and with a direction to deduct your lordship for the overlapping which has already been completed, your lordship, and he has complied and also dropped your lordship after compliance. So whatever payment has been made, that is to be deducted. Get this.
Well. Item 26.
Copy has not been served.
But it was storing copy. There.
This is a cover matter.
What covered matter? But he is entitled to look at it. And he will certify that it is a covered matter.
Cancellation. Cancellation.
Cancellation of the registration.
Your lordship. Your lordship. Your lordship. Just.
No, first go through it. Go through
It is central GST. You have made me party for that. He has made me the party, but not the grievance not against me. Central GST.
But better that you are doing the part.
No, your lordship knows very well that is without any good reason.
Filed an appeal. Filed an appeal.
Yes, my lord, I filed an appeal, but the appeal is rejected due to I filed the appeal, but
Beyond time.
The round of limitation which has been rejected, your lordship.
Then what will you do?
my lord, similar matter has been covered. But
Similar?
Yes, my lord.
It was not dismissed.
My lord, in
This is a special case where we have gone for appeal and appeal dismissed. Those were the cases where they did not approve the appellate forum. They straight away came. What to do?
Are you appealed under section 30?
Yes, my lord.
Section 30. What is that? Have you ever approached under section 30? Revocation. Have you made any application for revocation of that order of cancellation?
My lord, I appealed in 87 by 101 in 28 July, 28 June 2025. That appeal has been rejected. That appeal has been rejected due to filing the appeal.
What have I asked? Your registration is cancelled under section 29.
Yes.
Have you approached the authority under section 30 for revocation of the order of cancellation? Is it not the process? 107 is the process.
Your Lordship,
I mean,
that is another process.
correct or wrong?
Both processes are there. That is another process.
Both cannot.
He has now, without
Just
filing,
30 another scoper.
without filing 30, he has gone in appeal.
Anyway, Mr. We are not going into that. You have that copy of that order, similar my suggestion.
Annex 4.
Even deposit, whatever is there.
Let him file at your station.
Plus. Give him a copy.
This is a point.
Also, parking, I am not seeing he corrected the order. Whether he has corrected that order or not, I.
Help him out, sir.
Man. 27.
No correction is required in this case. It is a standard order your Lordship has adopted. Only name must be corrected. Only name, not actually number of digits.
Now, it seems to be
New. Double pitch number.
Right.
Let's
go the next.
Item 27.
This is covered by your Lordship.
162. Okay.
73. Sorry, madam.
No, you have said it is contrary to 168A.
Yeah,
It is not 73. Mr. Agrawal, this is 168A. 168A has other orders. There are pending cases.
Yes, my lord.
It is not.
Sir, I have signed.
এটা না আগুলো দিয়ে না দিলি কপি দাম
Your Lordship.
Yes, sir. This is the notification of.
Your Lordship. Your Lordship.
Yes.
Both are same.
Item 28.
168A.
That is different.
Item 28. 28. Sir.
This is relating to the central excise demand is raised by the central excise officer, the DGCI, Director General of Central Excise Intelligence, under section 11A. Though my involvement is not there, somebody has been made, my product is duplicate somewhere else, but my name is the main offender in the scope of duty. Then the matter was adjudicated by the commissioner, adjudicating officer, my demand has been dropped against me. Then department approached the Central Appellate Tribunal on technical ground. Since the so-cause has been issued on the notice number 1, the petitioner and the petitioner firm. So this order dropping of the demand against the petitioner is beyond the scope of the so-cause notice that is not maintainable. Then in that case, without discussing the merit of the case, the tribunal remanded back to the adjudicator for decision after hearing the both the sides. So, my lord, in this case, unfortunately, during this business, there were 15 years of gas. I have shifted from a rented house to my own house during the period some notice was issued from the department for giving the apology to the heart. But the notice could not be served on me. I am not aware of the figure.
You do not upload on the system that you have chosen.
No, actually, he has not done so because demand has been dropped against him. He was the bona fide prisoner. This is the technical matters. The department will rectified accordingly. So after during the period, no communication was communicated, and the department issued passed the order, deno order, without hearing me, and confirmed the demand against me 2 crores 75 lakhs, and imposed penalty also 2 crores 75 lakhs, and also interest. So meanwhile, a demand notice was issued of 5 crores 50 lakhs for recovery within 7 days. So that order, when I came to know that there is a demand recovery notice issued against me, and I got the telephone communication from, I approached the department in April, 20th April. Then I got the order. Then came to know that there is a demand against me, though I am not involved in this matter. There is no evidence against me. And the department also report there is there in page number kindly see page number 47 in the input so-cause notice at paragraph number 2.1.1.
In let the copy may be served to us.
Yes, I will ask you for the copy.
The Union of India.
Yes, for the process.
He is standing from some representing the department.
Oh, so I have given some my lord, some KDA. I have given you the copy. Some copy. Yes. How do you?
Look at it. He has given where is the
I have given the soft copy.
where is the proof? You have given it to Mr. Kedia.
Yes, ma'am. Actually, I am from outside. I do not know who is KDA.
Just
Let the matter be taken up tomorrow, then I will be verifying this.
Yes, sir.
I will take instruction about it. It's a Central Excise Intelligence. Generally, Vishwas is appearing on all these cases. Actually, Excise Intelligence matters, Vishwas is appearing. So that's your.
Is still going to take from the respondent not? Yeah. 11 September 2025, official book of it, official verify. If you know that counsel.
give him a copy.
Yes, I will provide that.
From where I go to Procedural. Where are you?
Actually, I am from Guwahati. I am practicing Guwahati, and that is the client which belongs to me. So I have appealed before that.
The staying back. The staying back.
If tomorrow will possible, then I will.
I'll take immediate instruction of work.
Immediate take instruction, tomorrow we are thinking this.
Yes, my lord. Okay.
Item 29.
You have checked?
Item 30.
Mayor, the petition in this case has approached this honorable court regarding issuance of notice under section 1 Act for the assessment and maintenance. And this similar assessing was before this honorable court in earlier assessment year in some allegation. And the rate question has been added. Allegation.
It is for another assessment here.
Another assessment. 17.
Madam, this is a matter pertaining to unexplained and discuss assessment in law. Notice has been issued, madam, under section 148, madam.
So Bharti, are you seeing this similar matter?
Similar, same.
For the earlier assessment here, the court has
You were appearing. You were appearing in this case also.
Under matter, this under court has nothing passed directly the assessee to comply the notice, madam. Then
No objection to complaint, but I am asking for documents. They are not supplying the documents.
have you gone through this judgment of ours?
Just to receive.
We have simply said that right to defend under section 148 is not taken away. Even 148A order is passed.
No.
If you go and contest that,
I have no objection to contest that.
you go through this order. It's of 1st July. That is our view. If you can satisfy our view is wrong, we are still open.
We supply you the documents.
They have not supplied the documents on
Annexer. At the stage of 148A, you sought for supply of certain document. Has it supplied?
No.
But proceeded.
But
Or it is still pending.
No, it is proceeded. They are proceeded. The passing
No,
order
148 final orders have been passed.
Final not passed.
Not passed.
Not passed.
Oh, then it is.
1-3 order pass. Thereafter they issue 148. After 148 we have filed the revised return. Then thereafter act on the assessment. That is the procedure.
148A3 order has come.
It has been passed.
That's what we are saying. Now, you sought for certain documents. Without supplying you those documents, he has passed final orders under 148A. Contemplating to issue, contemplating to proceed further in assessment under 148A by issue 148. Right? So, have you understood this?
Why the documents are not supplied? That's the genesis.
Right.
So it's a clear violation of the principle of natural justice. If he has asked for a document, you do not supply, and then you take that into account in your decision. Then is it not a violation of the principle of natural justice?
You have stated only one line. The submission of assessee are produced. However, as per findings of investigation, escaped page 32.
My lord, that's definitely.
So that to the conclusion, to proceed with. How can you do so? Without giving him the. Have you supplied?
No.
Have you taken instruction? You are not.
Take instructions, give us whether you have supplied those documents which they have requisition or demanded.
Yes, I will.
If we have supplied, matter ends. Let
Yeah.
them go and find under 148. And if not supplied, then he has a right to
Right.
disclose and explain.
His reply has to, on the basis of documents supplied.
Right.
His reply has to be considered. Thereafter, 148A order must be passed. If at all you proceed further or not.
Right.
Not funding.
Right, answer 2.
sheets are
Your
there.
Lordship, I'll file a detailed count.
What detailed count?
Your Lordship, for the first time he has raised this issue.
Mr. Mishra,
For the,
Mr. Mishra, this is the second stage. What Mr. So, the second stage, that 7 days, also another.
Your Lordship,
that
I have gone through that.
Pre-case stage.
Your Lordship knows very well once
Third
and
one
three
is
times
also
with
stage one.
me, then I have gone through every point.
That
Your
is
Lordship.
stage one.
Your Lordship.
Stage two, he has demonstrated. Stage three is delegation.
Delegation I can argue. Your Lordship, so far this first and second point, 41.4 and 42.6 points are concerned, Your Lordship. He has raised for the first time he has raised the issue. 2 times, Your Lordship, after assessment, 2 occasions, Your Lordship, short appeal has been made twice. Your Lordship, appeal has been made twice. So never he has got. I don't dispute that it is a question of Your Lordship.
Pure question of
I don't dispute. I don't.
will be.
Your Lordship, I'm well.
Basis of the material of the court.
I'm well conscious. Why I'm submitting these? Your Lordship, why I'm submitting these? Because for the first time this issue has been raised. So I have to go through the entire record as well as I have to confirm the department's instruction on these issues. Your Lordship, so far as the law is, that is well settled and I know Your Lordship all the grounds.
Here, say that even if the first date of appearance is taken into consideration, that is.
Then also 6 months.
He is not to service of notice.
Your Lordship, I bow down to my Lord Siri. And so far the delegation, Your Lordship, delegation, my Lord Siri may not have a case because in that Maharana supply, Your Lordship might have remembered that sales tax officer has passed the order, additional commissioner has done the revision. Whereas as per that 2009 notification, Your Lordship, one sales tax officer that is to be revised by deputy commissioner, one deputy commissioner that is to be revised by additional commissioner, joint commissioner, additional commissioner. So 2009 that has been gazetted. Your Lordship. Great.
I have there's already a demand. What you could kindly turn to parts.
Yes, sir.
Stays.
I'll counter. Your Lordship, I'll counter.
The challenge is
Your Lordship can ask the challenge annexure
also
8 and 10.
8, 10 and
That
3
is
also.
three.
That's the assessment
See,
order.
because all these grievances
That is all.
arose out of 3.
Oh, I understand. That is the assessing
And
of
because
the
of that-
30th of September.
Yeah.
Understand.
And
So,
fees also under challenge, the prayer also indicated.
30th September.
No, I had a third prayer regarding jurisdiction.
Jurisdiction, I can argue it just now. If your Lordship will permit, I can argue
Apart
just now.
from these two.
Much.
So that catchword is there that you have taken more.
Your Lordship, jurisdiction. Because all
I
these facts are.
I perceived what the energy level that comes. So the energy level which I found was low, I reflected it. Where the energy level is very high, I have kept it.
So if your Lordship allows the first one, other points need not be connected.
Even super 41-4 that is pending before our Supreme Court.
Sorry, 42-6.
42-6 is pending before Supreme Court, but on other issue in Cobra installation.
That 41-4 suffices this case.
41-4 ta achhi Supreme Court report.
There's no stay granted. There's no stay granted.
Judicial.
Many petitions have been allowed by this honorable court, keeping that 7 days limitation.
Is called somebody was mentioning in the matter.
But your plan-
Item
Yes.
35, item 56, item this is 56.
What is that?
One of the fulfilled matter.
Yes.
And posted to 13 on by the ASG is coming in another matter. And it posted to
13.
Yes, ma'am.
2 p.m. Because this, yes.
Item 56.
2 p.m.
56.
6.
My learning senior Mr. Chidambaram.
Yes.
Matter about. Tell your senior to unmute the system. I think his system is muted.
I've unmuted my lord now. Can
Yes.
you lordships hear me?
Yes, yes.
Okay. My colleague is there in the court. He will hand up an order under which notice was issued and an interim order was granted. This was issued by a bench of 2 learned judges, and then an interim order was granted. If you kindly come to
Yes, the
paragraph.
interim order is still today.
Interim order is till next date. No, next date of listing is today.
Yes, that's true. That means till today.
Yeah. Well, if your lordships are hearing it, of course it's today. But your lordships have held. If it is not heard today, it will continue until it's heard. Till next date means till next date of hearing. Your lordships are hearing it today. I accept your lordship's observation that it is still today. Now, kindly see the application I filed. Kindly go to the IA number 13361. It's a short
Which one?
application. 13361.
Flag C.
Item
I do
56.
not find flag C. Flag A is only there.
Flag C in your lordship's file.
2025.
It is not flagged.
What is
I'm
this? Sorry.
This is order.
No. This is the IA I have filed. I have annexed the order.
Huh? This is another matter.
Yes, another connected record.
56 years Lordship.
56.
No,
There
we
is
are
a connected matter. Which one you are referring?
Petition.
No, I'm referring to M.S.RAMAN. WP number 5215. 5215.
Okay.
Now kindly take my IA and come to the last page. The last page, the very last page of the 17-page document. Kindly see the right-hand column. It's in small print. I'll read it. The interim relief extended in the matter of WPC. The very last page, my lord, reverse of the page, very last page. The interim relief extended in the matter of WP 5215 by Honorable High Court has ceased to be enforced, and therefore the lessee has to pay the demanded amount for consideration of MDCC. The request made for issue of MDCC stands declined. He is assuming that since the matter has not been heard, it is expired. It is not expired, and he is now demanding the 1,360 crore.
Who is appearing for the other side?
My lords, I appeared for the other side, my lords. My lords, I am online, my lords. Sorry, my lords, I could not be in the court, my lords.
Yes, how can it be? When you knew the matter is there, then how the department can perceive there is already an interim order which is operative?
My lords, in this matter, in this IA, my lords, objection, if I may be permitted to file objection because this
When we are
application.
extending the interim order, you file whatever objection you want.
Oblige.
But this is not a way when the matter is still there and the interim order is already operative. How can entity proceed on that basis?
My lords, the application is 2023, my lords. And this is renewable for every year. They have to renew, and the clearance certificate has to be given. No dues clearance.
Oh, I understand.
My lords, there is an outstanding due of thousands.
And then you were supposed to file a counter. You did not file a counter as of
They
date.
have not filed a counter.
Let's file a counter, my lords.
When?
My lords, some time may be granted because I don't have any instructions with respect to the.
Awaiting your response.
Yes, my lords.
And notices were issued.
Yes, my lords.
Interim order was passed on earlier occasion.
Yes, my lords.
Still have not filed any counter. Can you proceed further?
My lords, only respectfully, if I may submit one thing, my lords, this application.
This is really the proving an example that I want one word in my hand to Bush also. Both. Everything will come to me.
My lords, the demand here is 1,000-something crores, my lords.
Yes, but it's been
Maybe
stated.
the quantum is not a material. The question is the legal right. And there was already a subsisting interim order. We are more concerned with that. If the order was subsisting, how can an authority in defiance of this order
my lords, the
raise
order,
this?
my lords, the order with respect to the demanded amount only, my lords. This, my lords, is the application of MDCC, my lords. The application mining due certificate, my lords. And with respect to that, this application is also dated 18th November 2023. And the interim order is of the present.
Show us that it is not interim order. As an interim order, it is directed that no coercive measure will be taken in respect of a demand notice number 5697.
Yes, my lord.
Of 8 September 2021.
Yes, my lord. That was with respect to the demand notice.
And demand notice dated 15th January 2025.
Yes, my lords.
Issued by the director.
Yes, my lords.
Till the next date. Now, this demand is not in relation to this.
My lords, demand is in relation to this, but the application.
Then how can you? I am asking you, if there was already a preventive order which is operating, then how can you make a demand?
My lords, this is not a demand, my lords. My lords.
Then what is this?
My lords, if I may refer to page number 7. My lords,
Please, he has referred the last page of the affidavit, which is flaxy. What it is? Tell us. If you say it is not a demand, we will record this. They are saved because they are really. What is this? The interim relief extended in the matter dated such and such by this has ceased to be enforced, and therefore the lessee has to pay the demanded amount. So what is this? If it is not a demand,
my lords,
do not know. My English is very bad.
No, my lords. My lords, the next line, my lords, the request made.
Mr. Joydeep Gupta is also appearing on virtually online.
I am in Ghanshyam Mishra matter.
Because we must have studied in the same school in Calcutta. That's why we are saying.
Yes,
English is very bad.
My lords, the only end that I'm trying to make is this application is only for MDCC, my lords. The application for MDCC stands declined. There is no demand per se, new demand notice, my lords.
Sir, madam, please, I have a bad knowledge of English. It's a foreign language, no doubt. What is the meaning of this word? Therefore, the lessee has to pay the demanded amount for consideration of the MDC. What is the meaning of the word demanded amount? Amount which comes within the demand notice, then it will be a demanded amount.
My lords, if I may be permitted to bring on record all the details, my lords, by way
You
of.
bring on record, but don't defy the interim order passed by the court.
It should be MDCC.
Don't defy. Why are you defying the interim order? We are extending the interim order.
My lords, if this matter may be taken up next week, then my lords.
Whatever you want. You file your affidavit counter. You are in default, and you show your hurry that I am in hurry, but you are not showing your bona fide. You could have filed your counter.
My lords, I understand that, my lords. I
To
understand that.
comply with the order of this court while issuing notice.
Sorry, my lords, I could not hear, my lords.
In absence of compliance of order of this court, that you should file counter.
Yes, ma'am.
And how can you say simultaneously to defy this interim order?
My lords, that I understand, that portion, my lords, I understand.
Lakho, the interim order
together.
Because, my lords, they are some way interlinked. There are 3 different batches, my lord. Let it come on the next date, we'll segregate them.
No counter?
No.
No
The
counter?
counter has been filed in most of the cases after your lordship's intervention on the last occasion. Order number 9, my lords, your lordship said counter is the last chance. Except 1 or 2, my lord, counters have been filed in all the cases.
In one of the cases, counters have been filed, we'll file rejoinders shortly, the first place.
One matter has to be segregated, otherwise then I will release all the matters.
My lord, on the next date, we will give your lordships a chart, my lords. Let it come after 2 weeks.
One matter has to be segregated. So we are segregating this matter. Let it go. This 30390 release from.
Interim order continue.
Yes. Do not list any matter tomorrow, any new matter. Don't list. Let us see how far they can argue. I will also dictate the judgment in the open court. I will not take any new matter. All the old matters that will continue. Correct? No difficulty. And no adjournment on any ground. And my assurance, immediate judgment to be delivered in the open court.
My lord, in item number 51, I have received the counter. Kindly allow me to.
Look at it, we are really grappling with all the situations every time. Why you are insisting? We are taking up the matter any day.
No, my lord.
We'll take up the
I
matter.
want time only to file rejoinder.
You file your rejoinder, don't worry. Take care. Do it.